Welcome everyone to New York Case Winning Strategies, Mastering the Skills of New York Civil Practice. This video is the first of a short two-part summary of the entire series. In this video series, we share with you the knowledge and insights gathered from over 30 years of practice in the trial of civil cases in New York State Supreme Court. Armed with the knowledge and insights that this video will provide, you will greatly enhance your prospects in successfully prosecuting or defending a civil action in the New York civil courts. Although the information provided in this series is intended primarily for the New York civil practitioner, it will also be a very useful resource for candidates studying for the New York bar examinations, law students aspiring to become civil litigators, as well as law professors, paralegals, process servers, and all persons seeking a deeper understanding of New York civil practice and procedure. The first topic that we will cover in this video series is personal jurisdiction and service of process. We will discuss service of process upon natural persons as well as artificial legal persons such as corporations, limited liability companies, partnerships, limited partnerships, and municipal agencies such as the City of New York and its various departments. We will examine the various requirements for service of process within New York State and contrast those rules with the ones governing service of process in states outside of New York. Under the first subdivision of Section 308 of the CPLR, we will examine seemingly straightforward situations of service by personal delivery as provided in Subdivision 1. We will alert you to simple errors in personal delivery scenarios that must be avoided so that your case is not dismissed for lack of personal jurisdiction. This video series will examine in detail, also under the rubric of personal jurisdiction and service of process, the concept of substituted service as that term is used in the CPLR and applied by the courts. You should note that the CPLR does not use the term substituted service. However, the concept is at the core of CPLR Section 308 jurisprudence. So, on the topic of substituted service, we will give you a thorough analysis of the specialized terms and concepts used in that section, such as the following. Quote unquote, a person of suitable age and discretion. What exactly does that mean? Who qualifies and who doesn't qualify as a person of suitable age and discretion under CPLR 308? Subscribe to the series and find out. Then there is the phrase, defendant's actual place of business, dwelling place, or usual place of abode. We will also dissect and analyze the phrase, nail and mail service, otherwise called affix and mail service, as well as the term, quote, last known residence, and the various scenarios in which the courts have determined what does and does not qualify as a defendant's last known residence, and so on. These are terms of art contained within CPLR 308, and they have specialized meanings as used in that section. They are not necessarily used in the same way that they are defined in Webster's dictionary. So it is vital that you understand the legal meaning ascribed to each of these terms so that the client's rights can be adequately safeguarded in the event that there is litigation involving a challenge to personal jurisdiction. Now, the application of these and other similar terms of art in New York civil procedure will be examined in conjunction with a review of the relevant leading cases decided by New York State Supreme Court, the Appellate Division, and the Court of Appeals. After our discussion of words and phrases with specialized meaning in the area of substituted service, and after our discussion of personal delivery under Subdivision 1 and certain special rules relating to personal delivery, we will go on to examine the authorized methods of substituted service. That is, service upon a person of suitable age and discretion under Subdivision 2 of CPLR 308, as well as nail and mail service, otherwise called a fix and mail service, pursuant to Subdivision 4 of Section 308. Further, we will discuss in detail the procedural steps that a defendant must follow in order to validly designate an agent for the purpose of accepting service of process on his or her behalf under Section 308. The series will proceed to take a close-up look at the special methods for service of process in divorce cases. In this regard, we will learn that apart from the explicit service provisions of Domestic Relations Law Section 232 for service of process in divorce cases, that section, Section 232, also permits a divorce plaintiff who is unable to personally serve a defendant to obtain a court order under CPLR Section 308, Subdivision 5, which authorizes service by any of the methods specified in CPLR 308. We will look into these provisions in detail. Now, apart from divorce cases, what if the defendant in a civil action cannot be located and service therefore cannot be made by personal delivery, or by suitable age and discretion service, or by nail and mail service? In that case, resort must be had to Subdivision 5 of Section 308, which permits a plaintiff to make an ex parte application. An ex parte application is an application made directly to the court without notice, without serving notice of the application to the intended defendant. So Section 308, Subdivision 5, permits a plaintiff to make an ex parte application to the court requesting that the court devise or order an alternative method of service of process upon a defendant who cannot be found, usually by publication in a newspaper, by email, or by posting on social media. This video series will go on to cover service of process and common jurisdictional issues arising in summary landlord-tenant proceedings to recover rent arrears and to recover possession of real property, otherwise known as eviction proceedings. Now, with all of that said, when is service of process complete, quote unquote complete, as contemplated by Section 308 of the CPLR? As every proficient lawyer and indeed every earnest bar examination candidate and paralegal knows, service by in-hand delivery is complete upon handing process to the defendant. However, what is less commonly known, but is nevertheless of crucial importance, is the fact that substituted service, that is, service either by delivery to a person of suitable age and discretion or by the nail and mail method, is not complete until 10 days after certain procedural steps are taken and proof of compliance is thereafter filed with the court, again, within a specified time. We will discuss all of these procedural steps as well as the time frame within which they must be completed in order for service to be valid and jurisdiction obtained over the defendant. Now, after service of process is deemed quote unquote complete under the rules of Section 308, this video series will teach you all about the time provided for the defendant to respond to the service of process, depending on what method of service was utilized, and depending also on whether the process served was a summons and complaint or a mere summons with notice. The rules governing the time within which a defendant must serve an answer or otherwise respond to the service of process are to be found in two main sections of the CPLR, those being CPLR Section 3012, Subdivision C, and CPLR Rule 320A, Subdivision A. That's CPLR Rule 320, Subdivision A. Also, on the subject of personal jurisdiction, we will introduce you to the Traverse hearing and review the situations in which such a hearing is ordered by the court and the reasons. Our website, NewYork'sCaseWinningsTrategies.com, offers Traverse hearing transcripts of actual New York cases. The transcripts provide first-hand court testimony, including direct and cross-examination of process servers, private investigators, defendants, and other witnesses. The transcripts also contain opposing legal arguments by the attorneys, as well as discussions between the judge and the attorneys on both sides of the issue, relating to admissibility of certain kinds of evidence, including the operation of the rule against hearsay at the Traverse hearing, and much more. So, that is basically a broad overview of the topic of personal jurisdiction and service of process that will be covered in this video series. And that brings us to the conclusion of this first of the two-part introduction. See you in part 2. Thank you for watching.